Afternoon, folks. This is the Setzler Subcommittee. I'm going to bring it to order. Setzler is presenting still in the Senate committee upstairs, so I'm going to kick this off. But before that, we do that. Let me ask a word, a blessing. We bow real quick. Dear Heavenly Father, thank you for the blessing you bestowed upon us, Lord. Give us the wisdom and guidance necessary to do the business of the citizens of Georgia. We ask all this in your Heavenly Son's name, Jesus Christ. Amen. All right. Thanks for coming to us late this afternoon. I appreciate you making it over. And for those of you online, we've got a couple measures we've been working on, and we want to, as the days are getting slim, we want to make sure to try and get these things moving if possible. I'm going to go ahead and move into Senate Bill 174, and maybe at some point Chairman Cecil will make it down, and we will turn it over to him. If not, then I'll move on into the next measure. I've got two measures here. I got Senate Bill 174 and also Senate Bill 85. 85 is the hazing bill, and 74 is a OR bill. Um, First off, I want to make sure everybody's got the right substitute. Senate Bill 174 LC 413170S. And so the issue is, if you recall last year, I think Chairman Fleming carried a bill that addressed an issue where bonds were being issued that for crimes where there was no actual security for the bond on several types of offenses. And so what we did was we put together a measure that said that there are a few um, crimes that we do not want to release. We're making a policy decision to say that we want a security in place so that we can assure these folks get back to court when it comes time to um, um, have trial. In the interim, since we've passed that law, we found we need to clean up some of the language because some of the cases or courts have been construing the language we had, and I'll walk you through it. It's line 13. They've been construing this language to mean that the only offenses that we could um, not use the OR bonds on, or not only these, but I guess every other offense that they're using. So that they're getting in Atlanta. So Atlanta, Fulton County, and metro areas, I think where we're having the biggest issue. And so what we're trying to do is assure that with this language, the judges understand that it's a decision made by the legislature as to when the ORs are capable of being used. And I think everyone's got in their packet this a few of these sheets just to kind of give you an idea of what some of these um, courts are allowing an OR bond, which is on your own recognizance. So there's no security required. And then again, these folks are not returning. So there's really no sense in there's um, no hook to get them back to court. Um, One of the examples I've got here is armed robbery, hijacking, motor vehicle, aggravated assault. All of these crimes that we have deemed to be um, included in the exception of the OR bond. And what this bill also does is adds a few other crimes. It also adds burglary, and it adds entering an automobile and stalking, both misdemeanor and felony stalking, and then also crimes involving family violence. And um, there's some cleanup language to make sure that Representative McLaurin was talking about this earlier on line 69, an appointed judge filling in the vacancy of an elected judge versus just saying an elected judge. And that's the gist of the measure. So I want to open it up for discussion. I mean, please feel free to jump in here. Let's work through this thing and see if we can come to a consensus here. Representative McLaurin.
Thank you, Mr. Chair. My first observation is all of these cases seem to be from Fulton County, and I think the chair just acknowledged that seems to be the focus. So, I'm coming at this discussion the same way I did SB 402 last term, which is if the speaker needs to make a committee on special access to Fulton County justice, then let's just do that explicitly. I mean, part of the issue here is we're trying to resolve a problem with a bludgeon that goes a lot deeper than just individual bail determinations. This was our opposition to SB 402 last term as well, which is we had a former DA who charged, I think, more often than this DA will in cases, more aggressively, and wasn't as concerned about jail capacity. And hopefully we're moving on to a new era in Fulton County. But in the meantime, the jail has had real difficulties with capacity. I've toured the jail. They used my stock photo just a minute. Somebody was like, "You're in the paper on the jail." I was like, "I haven't been in the jail in a while, but the jail's in the news enough that I guess I got to use the photo." Right. So people sleeping in, these like plastic boats or whatever out in the middle of these dorm facilities, and COVID has been spreading. We know the story. So, that's the reality that these judges are facing when they make decisions about when somebody comes in front of them and they're trying to assess the flight risk, the risk of reoffending. That's what's coming into mind. And so, we get these sort of scare sheets all the time whenever we have a bill and they don't have any context, and we have no way of talking to anybody who is involved in these cases to know what these three, duly elected or appointed Superior Court judges who I respect were thinking. But at the end of the day, the picture is just a lot bigger than individual, gotcha sound bites about how these determinations are made. So I guess my point just in general to start with is, if what the business of this committee is going to be is to come back year after year and say, hey, just a little bit of cleanup, we'll just sprinkle two or three more fences on. I mean, it's one thing to honor Chairman Setzler's request, let's keep this discussion cabined, right? And let's not talk about the cash bail system as a whole, because all we're talking about today is XYZ. But at some point, this becomes a conversation about cash bail system that's creeping ever larger, and a system that doesn't allow judges discretion in one county, my county, no other county that is really the concern here, rather than looking at root causes. So I'm going to be a hard no on this, but if you want a technical suggestion on lines 73 to 79, I can give you one. And that is, I think they're redundant because of the way that it's been struck. So you probably want to take out one piece of that, either the 73 through 74 piece or the 75 through 79 piece, because I think at this point they do the same thing now. That's all I got for now.
Thank you, Representative McLaurin. So I understand, the way I understand your argument is that the judges are dealing with an overwhelming population within the jails, and so should we leave it to the judges to just if someone comes in and I understand your point about the context not being there, but there's certainly been a DA somewhere that we're here in Fulton that charged someone with armed robbery and 4 counts of it. You're thinking and is that we should just leave that with the judges and let them make the determination to not necessarily have any type of measure in place to make sure that they come back to court to be adjudicated based on the facts of the case. Is that your position?
Well, the position I'm making is a couple different things. The first is that this is a statewide rule change to restrict judicial discretion because of what's ostensibly and still is, based on the presentation of this legislation, a Fulton County issue that Fulton County legislators have fully acknowledged and said, I mean, we set foot in that jail. We understand that's a problem. And the sheriff, has a way, the new sheriff is proposing more space. I mean, there's different ways of approaching the issue, but ultimately My biggest problem is that this is a statewide bludgeon where a more thoughtful assessment of one county's problem is in order. That's the first issue. The second issue is I have made a case today where if Chairman Setzler is to join us, I will reject his suggestion, which is something I did not do last term, that this is not a larger conversation about cash bail. Because the problem is year after year, I've now unfortunately been here long enough to know that these things are incremental. More offenses maybe get sprinkled on every year. And we're now deepening, widening cash bail as a response to the issue of, will somebody come back to court? How do we ensure that process moves on? So, again, bail is supposed to be about two things. Well, it's about public safety, but it's about flight risk and it's about reoffense. That's it. It should not be about willingness or ability to pay, right? And here you've got a situation where if somebody can pay, they get out and maybe they do reoffend or maybe they flee. If this were a graph, those arrows would be they wouldn't intersect. The idea that somebody's ability to pay and public safety, those lines just don't touch. So to have a system that's ostensibly about public safety, but we're making it about ability to pay is criminalizing poverty straight up. And so this bill deepens that system, the use of it. And if the question is, well, what's the alternative? I don't know. We have these treatment programs. Each of these X's here on the line is released to pretrial services supervision. So if we were having more of a conversation about what the terms of that supervision were, what kind of conditions were imposed, how effective our community presence is, that would be a fruitful conversation to have in response to the problem. But just tightening the screws on one side of it and saying, figure it out, Fulton County, is not how I think we should be doing policymaking. With respect. Thanks, Mr. Chairman.
Thank you, Representative McLaurin. Representative Smith.
Thank you, Mr. Chairman. As I understand it, this is not just a Fulton County problem. I believe it's also an issue in Athens, Clark, DeKalb, and Clayton County as well. Look, I wish Fulton County and these other counties would get their acts together, but if wishes were ponies, we'd all take a ride. I think this is a much needed change. And just speaking as one who has had to represent criminal defendants in a court of law in this state and several counties in this state, there is an issue of securing their presence back at court and aiding in their preparation. So I think to say that this conversation is getting into anything other than what this bill is purporting to do, that's a little much.
Right. You're good, go.
Looking at some of the stuff we have before us, I'm just incredulous that that there have been bonds set in some of these cases, especially on an OR bond. It floors me just from where I practice that a judge would do this. And if this is starting to be a problem, if heaven forbid this is a situation where somebody's trying to impose their view about our cash bond system, sitting on a bench, trying to make a policy decision by sitting on the bench. That doesn't seem to be too impartial to me. So I think this is a good correction to the code section, and I'm fully supporting it, Mr. Chairman.
Thank you, Representative Smith. We got Representative Chairman Burt Reeves. I'm going to call on you. Your go.
Hey, can y'all hear me?
Yes, we can.
Okay. Wanted to raise a point to kind of counter what my good friend Representative McLaurin said. If I recall last year, the one of the bases of this legislation is that we have judges were setting OR. A person was given a bond of $5,000, but then being let out on an OR bond where it appears as if they had a bond, but then they're being released on their own recognizance. And that was a practice that I'm not sure that we figured out where to trace where that came from and how it started and how it was used. But if I recall, this bill or the bill last year that was passed does not permit or doesn't it does not prevent a judge from setting a $1 bond. And so you can't, respectfully, we can't say that this is criminalizing poverty when a judge would have the ability to set a $1 bond in any case. And that would be a bond that they would be setting and their name would be on it. And that's why we did the whole thing, was that their name is on that now that they've said that $1 is the right price for a bond. But what the problem is that there's the appearance that that they have a much higher bond, a realistic bond based on the charges. But then the truth is that they're released without posting any bond. And so I think we cannot let that escape us, that a judge under all of this could still set a bond for $1. That's all I have.
Thank you, Chairman Reeves. Representative McLaurin.
Thanks, Mr. Chair. And to my colleague, who I respect very much, Chairman Reeves, the history that I remember on this bill, SB 402, is that the current chairman of the Judiciary Committee was not comfortable with the bill. I think he even voted against it. If I recall, I'd have to go check, but I don't think he voted for it. Something probably related to that was that this bill got moved. SB 402 was moved from Judiciary Non-Civil to House Judiciary, who at the time was chaired by Chairman Barry Fleming. I attended that committee hearing in person when it was passed out of full. At that hearing, Representative David Dreyer, this is my personal memory, right, that I'm talking about, said to Chairman Barry Fleming, but a judge would never issue a $1 bond because of the optics of that. To which Chairman Barry Fleming responded, "That's the point." The bill passed out of full committee. The bill passed on the House floor. So respectfully, Mr. Chairman and Chairman Reeves, that is not the history that I remember. Thank you.
Well, am I still live?
You're still on.
Mr. Chairman, if I may.
Yeah, go ahead.
The whole point of it, this is it 6 or 1/2 dozen? The point of it is transparency and accountability to a judge. And for a judge to set a bond at $5,000 and release someone on their own recognizance, is there really any difference in doing that than issuing a $1 bond? And so instead of essentially fooling the public that there's a $5,000 bond here, why not own it? And so I recall it as you recall it. I guess I see it differently, but the whole point of this is that judges are being able to hide under this fact that they're releasing people in many cases, as we heard last year. And I don't know what y'all are looking at today, I'm not there, but who've reoffended in major ways, who were in on very serious crimes. They have the option to give them a $1 bond. And if they want to release them on their own recognizance, well, we're going to say you can't do that anymore, but you can release them on a $1 bond. What's the difference? It's not hurting. It's not hurting any place where the practice is not being abused. We do things all the time in the General Assembly because of isolated areas where things are happening. We do things all the time because of that. Frankly, we do things all the time because of Fulton County. And everybody knows that. That's all I have to say.
Thank you, Chairman Reeves. I'm going to give you a minute to respond, Representative McLaurin. But just kind of paraphrasing what Chairman Reeves said, if the judge's intention is to release for no dollars or for no security, and then what is the harm in putting $1 down for bond? I'm just rephrasing essentially what he said. So go ahead, Representative McLaurin.
Thanks, Mr. Chair. I mean, I'm glad that nobody challenges my memory of the exchange between Representative Dreyer and Chairman Barry Fleming, because I think that exchange was illustrative that ultimately, practically speaking, this is an optics bill. There's a reason why the phrase unsecured judicial release was used. Unsecured meaning hide your kids, and judicial meaning it's the judge's fault, and release meaning they're out, they're free. Okay, these are signals because OR is a term of art that lawyers know. This is a clarity bill. I think Chairman Reeves said it best just a minute ago when he said, own it. The public needs to know. Whatever you think about whether that's good policy, that was the point of this bill. Everybody can agree that that was the point of the bill. But I return to my original point, which is if it's not that likely that somebody's going to exercise that option, if a judge doesn't see that $1 bond as a real option, right, then what the bill effectively did was SB 402 took away a middle ground position, and it forced judges into one of two extremes, either this sort of, foil of a term, unsecured judicial release, or push them in the other direction to a secured cash bond. So again, we come back to the cash bail system, which is under attack nationally because it criminalizes poverty. And there are no easy excuses or ways out but you could just do X, because I think we've agreed on the record, both last term and this term, that it's not about, it's that option's not a real option, even if it's technically there. So, that's going to be the nature of our opposition to this. I understand what the bill is supposed to do. I understand why it's moving terms around, but we're rearranging deck chairs and we're making the boat sink a little faster. So thank you.
Well, I appreciate you, Representative McLaurin.
Mr. Chairman, can I say one more thing?
I don't think we have anybody signed up to speak to this measure. Being we're in subcommittee. Well, I got a flashing light. Hold on a minute. Chairman Reeves, did you want to say anything else? Your hand's still raised.
Yeah, can you hear me?
Yes.
I don't know that I can count high enough to recite how many bond hearings I've been a part of in my career. And to say that a judge may not be aware of the tool of being able to issue a $1 bond, there's not a defense attorney out there that wouldn't be situated to remind the judge that, Judge, even though you can't issue an OR bond, you could issue a bond of $1 or $2 or $3. And the reason why I think this is interesting, because I think we're all agreeing on, I think Representative McClure and I are agreeing on a lot of things. We just see it differently, but it's a facade. And again, wherever the OR bond issue originated from, so be it, but it's being abused in places, and it's a facade, and it's not transparent. And to say that the judge, and maybe I misunderstood Representative McLaurin, but to say that a judge may not be aware of that option, I think that any competent defense attorney would be willing and prepared to advise the judge that that is an option. So I think that, this is an accountability measure is what this is. And I think I mean it when I say, I think I've said all I'm going to say. I don't think I'm going to say anything else. All right.
Thank you, Chairman Reeves. Representative Smith.
Mr. Chairman, at the appropriate time, I move do pass.
Now's the appropriate time. You got to move, do pass. Do we have a second?
Second.
Do we have any amendments? Representative McLaurin.
Yeah, I can't help. Thanks, Mr. Chair. I can't help trying to assist a bill I'm going to vote against. So lines 75 through 79, or technically it really only be text on 75 and 76. But I would strike that. And I would also strike on 73 the language from except as provided all the way through the comma, and capitalize the T. And what that does is eliminate the redundancy that this sub introduces.
Will you explain that a little bit further there?
Sure. So right now it's from 69 to 74, subsection B. It's saying you can issue an unsecured judicial release if, and then it says except as provided in subsection C, the person is not charged with a bail restricted offense. But then all C does now, given the changes, is the same thing. It says a person charged with a bail restricted offense shall not be released on unsecured judicial release. That's an identical provision, as far as I'm reading it.
So then wouldn't we then have to take subsection C out of these other sections?
Yeah, I guess that would be smart, Mr. Chair. I agree. You'd go through and anywhere there's a reference to except as provided in subsection C, you would strike that.
Give me a second. Let me read through it there, Josh. Excuse me.
Yeah, it might be a little more involved than I said.
we've got a motion for an amendment. Do we have a second? Do we have a second? The motion dies for lack of a second. We've got a move to pass and a second. All those in favor of any more discussion, excuse me. No more discussion. All those in favor signify by saying aye.
Aye.
All those opposed?
No.
All right, that passes on the full committee. Let me check on Chairman Setzler. Let me suspend for about 5 minutes, see where he's at. Thank you all for being patient with us. Setzler's still presenting a pretty important measure up there in Health and Human Services. So I'm going to try, we've got Subcommittee Chair Reeves on the line, and I'm going to ask him to go over this hazing bill. We've done some significant work on changing the language in it, and both subcommittee chair or Chairman Reeves and Chairman Setzler have worked tirelessly on this. So I'm going to recognize you, Chairman Reeves, if you would. Got Senate Bill 85 in front of us, and would you mind running through the changes that we made?
Sure. Can y'all hear me again?
We can.
Okay. So Chairman Setzler and I probably spent about 2.5, 3 hours yesterday afternoon, really going through this and contemplating the senator's intention and making sure that what we were doing was something that was addressing a valid concern, but that didn't go further beyond, which I think that there was some concern initially that aspects of the bill were very overbroad. And that's, again, I said this in the last hearing and I say it again, it is in no way to make light of the very serious tragedies that have happened in Georgia and other places, and where Georgia families have lost their children because of some very nonsensical behavior. And there are laws that already cover the concept of hazing, and what we did is the bill as presented to us expanded that, and what we did in this committee was, I think, try to draw that in a little bit to address the particular issues that we're really looking at. And I think that it's safe to say that it's really the coercion of forcing people, either through social pressure or physical pressure, to do things that are not healthy, like to consume any kind of food, liquid, alcohol, drug, or other substance, which is likely to cause a risk of vomiting, intoxication, or unconsciousness. And this is obviously directed, 95% of what this would be is forcing, a young person to binge drink. And we know that there are some unbelievable tragedies that have occurred because of that. And so if you look at the definition, the definition largely is as it was before this bill, but then we've added this concept that's really elaborating on forcing someone to eat food, liquid, alcohol, or drugs, or other substances. We left the kind of cleanups in that incorporated to make clear that TCSG and any private post-secondary school, so private schools, that their students or their organizations have culpability under this, just as our USG schools do. And then the rest of the parts of Section 1, I believe we left untouched. With going down to Section 3, and I'm sorry, I just meant to say Section 2, we left untouched. Going down to Section 3, this is a real substantial change that I think really addresses the issue that the author wanted to achieve. And that's, if a fraternity or sorority or any other organization, I realize that we're mostly talking about fraternities, but it's certainly more inclusive than just fraternities. But just for hypothetical and context reasons, if we're talking in terms of a fraternity, if a fraternity has had violations that have been adjudicated by the school, and I believe wholeheartedly that University System of Georgia and all of our schools take this very seriously. I know that for a fact, and I think I said this in the last hearing, but 21 years ago, I was the Interfraternity Council president at Georgia Tech, and I knew how serious it was then. And I believe that there's been even more that's happened in the student codes of conduct, et cetera, in the last 20 years to address the issue of what happens in Greek life and in other organizations. But the point of what Section 3 really stands for is that if you are a parent and your child is going through rush and is considering joining a fraternity or sorority, you ought to be able to look online and find some kind of disclosure, public disclosure about organizations that have been adjudicated through the school process for hazing. And so what we did was we in section 3, what we mainly did was we drew a difference between the concept of alleged incidents versus adjudicated incidents. And the reason why is that this is, there's a lot of room for potential retaliation in this of allegations. And it seems most appropriate, knowing that we anticipate the universities are going to continue to take these matters and these investigations very seriously, to limit it to actual bona fide adjudications as opposed to allegations. And so under this, it would require that all of our schools would have to have some kind of publication so that the public can look up and see fraternity XYZ, has in the last 5 years has been adjudicated of 2 hazing violations. And so, but before I wrap up, I think it's also important to note that I think this is a good thing, and I think that this does create public awareness. And I also think that the leadership of a fraternity organization, the cabinet members who lead that organization, they're very conscious of things like this, of making sure, this would not be a good list to be on, right? And I do think that it adds to what there already is, a good bit of deterrent on hazing. And I think culturally, things are a lot different than they used to be. They're still not where they need to be, but they're a lot different from where they used to be. But I think that this concept does create a good deterrent. But I also want to say that it is important to note that I think that universities do take hazing very seriously, and there are different degrees of hazing. But anything that is causes physical injury or things involving alcohol or drugs, those are issues that I believe that universities are addressing, and they're addressing in a very strong way. And I know that there have been many fraternities across the state of Georgia in the last 20 years that have had their charter revoked because of these type things. And so I think that there is a lot of effort around this. I think what this does is it adds another slice of deterrence for fraternities to ensure that the culture that they're creating is one that is acceptable, and that anybody that is a rush chair that is tasked with and charged with rushing 18-year-olds and attempting to get them to join the fraternity or a sorority they are not going to want to be on a list like this. They know that would be detrimental, and that this would be something that would be very damaging for a fraternity. So I think that it does help achieve a really good public policy goal in that. At some point we had talked about potentially carving out a specific civil remedy, but I know this. I've advised informally my fraternity from Georgia Tech, in my role as a lawyer through the years. There are lots of causes of actions that any plaintiff lawyer can pursue against a fraternity or even broader other student organizations. And I don't think that I don't think it's necessary to add that. I think that the law provides plenty of avenues to do that. And so we, after a long debate and getting some input from others, we struck that from the bill and kind of simplified it. And again, our goal was, let's look at what Chairman Senator Albert's goals were, and let's do something that achieves those goals. And so that's where we are, and I'm happy to take any questions.
Thank you, Chairman Reeves. Committee have any questions? Anybody online have any questions? We've got a one person signed up to speak to Senate Bill 85. And that is Maisie Lynn with GATCO. Maisie, will you unmute yourself and Welcome to the late afternoon committee and Judiciary and Non-Civil Subcommittee.
Can you hear me okay, Chairman?
Yes. Good to see
Thanks
you.
for calling on us. We, after hearing and seeing the substitute bill, we have no concerns about the bill, but thanks for calling us out.
Well, thank you. Thank you for signing up to speak. We got a flashing light here. Representative Smith.
Mr. Chairman, at the appropriate time, I move do pass.
Now is the appropriate time. We have a move do pass. Do we have a second? We have a second. Are there any amendments, proposed amendments to Senate Bill 85 LC 413163S for passage to full committee? Hearing no amendments. We've got a motion to pass in a second. All those in favor of passage of this measure to full committee signify by saying aye.
Aye.
That's all three of y'all. So there's going to be nobody opposed. This moves on to full committee, and appreciate your patience late this afternoon and working on these two measures. And we'll Representative McLaurin will look at the amendment that you proposed, and we get a second on that. I don't have an issue with it in full committee. With that, I'm going to adjourn and thank you all for sitting in.